And by the way, lest you wonder whether criminal prosecutions can act as an effective deterrent to crime in the white-collar arena, statistics show that in the years following the Tyco prosecution, state tax revenues increased by $85 million, a phenomenon the New York State Tax Department has referred to as the Kozlowski bump. The lesson from this prosecution is really very clear. And in training our assistants, we stress that any case that walks in our door, no matter what the initial subject matter, can potentially lead to a significant investigation and quite possibly in areas far afield from the original complaint. This is especially true in the types of cases that we talk about tonight. And just as it is important to connect the dots internally and forge ties across the diverse units within our DA's office, we have also, over the past year, strengthened and in some cases forged new relationships with outside agencies like the SEC, the CFTC, FINRA, the Federal Reserve Bank of New York, and the Depository Trust and Clearing Corporation. Just this past fall, the Manhattan DA's office conducted its first ever banking symposium, which attracted nearly 400 participants from industry and enforcement. The event was hosted by the Federal Reserve Bank of New York and brought together all the agencies I talked about and more representatives of the banking industry in an effort to better cooperate to both solve crime and, equally importantly, to try to prevent crime before it happens. And the cooperation is yielding results. This past September, we announced indictments in a large international cybercrime ring in a case that arose from joint investigative efforts involving our office, the FBI, and the U.S. Attorney for the Southern District. And I look forward to many opportunities for cooperation of that kind in the future. In talking about the unique role that our office has to play in meeting the challenges of sophisticated fraud in a 21st century economy, I'd like to start by talking about the Martin Act and how we have used it and how we as an office will expand its use. As many of you know, the Martin Act is the New York State law under which we prosecute securities fraud. And it was originally enacted in 1921, 13 years before the Federal Act forming the Securities and Exchange Commission was enacted, and indeed 18 years before the term white-collar crime was first coined by Professor Sutherland. The Martin Act was intended as a broad grant of authority to investigate and prosecute, as the Court of Appeals famously stated in the Federated Radio decision in 1926, all deceitful practices contrary to the plain rules of common honesty. That judicial construction, elegant and simple, makes the Act sufficiently flexible to prosecute a broad range of frauds. The Martin Act is a false statement statute, not just a fraud statute. To lie or deceive someone in the offering of securities, no purchase or sale is necessary, violates the law. And this past year, using the Martin Act, to name just a few cases, we've prosecuted large-scale Ponzi schemes, such as a recent indictment of a foreign national who enticed investors and friends into a multi-million-dollar scheme by falsely claiming he was a member of the Chimay royal family of Belgium with access to royal family money. We've used the Act recently to charge fraud in connection with national schemes to fraud investors to purchase gold coins and to file charges against those who gave friends and family millions of shares of illegally issued stock in a scheme to steal more than $60 million. But these, quite simply, are just a few examples of the Act's traditional use. My focus is on its future and its broader application. In the coming year, in part because of the new relationships with enforcement partners that we have forged and a proactive approach to enforcement, I expect you will see the Martin Act as a criminal enforcement tool in prosecutions of investment frauds and Ponzi schemes involving investment funds, investment frauds using privately held companies, fraud schemes that actually target broker-dealers, manipulation of commodities and commodities futures, and insider trading in securities and commodities. I must tell you, I believe the Martin Act has never been more relevant. In recent years, our entire nation has become painfully aware of the devastating toll on our economy that results when widespread mistrust infects financial markets. Without trust, quite simply, our economy ceases to operate. No bank will close on a loan when no one can rely on the truthfulness of the representations in the application. No investor will purchase a financial instrument when there's no assurance that the security that backs it is real. And that's why we must continue to uncover those deceitful practices that the Martin Act has outlawed for the better part of a century, those practices that are contrary to the plain rules of common honesty. But the flexibility of the Martin Act and its utility in the battle against criminal fraud is marred, I believe, by its overly lenient penalties. The highest level crime, which at its simplest involves intentional false statements resulting in a loss of over $250, is only a Class E felony with no minimum term of imprisonment, regardless of the amount of money involved. Thus, a broker who fraudulently deprives one customer of $500 is subject to the same penalty as a high-level market manipulator who deprives the investing public of hundreds of millions of dollars. And in either case, a state court judge would be authorized to impose a non-incarceratory sentence. This year, as part of my legislative proposals, I will be calling on the legislature to reform the Martin Act, to make it even more powerful in the battle against fraud by conforming the penalties for different loss amounts to those in the current grand larceny statutes, and by increasing the statute of limitations for Martin Act misdemeanor enforcement. Thus, the small-time broker who defrauds his customer of only $2,000 would be subject to a Class E felony maximum of 1 1/3 to 4 years, while the sophisticated market manipulator or perpetrator of a large-scale accounting fraud would be subject to a prison term of up to 8 1/3 to 25 years and a mandatory state prison term of 1 to 3 years. It's interesting that I'm not the first district attorney to complain about the Martin Act's bite. In 1925, D.A. Banton stated to the New York Times about the first iteration of the Martin Act law, which then lacked criminal provisions and granted immunity to anyone who testified in connection with securities investigations. Banton noted, and I'm quoting him, "It is said that the Martin law has teeth. It has, but they are an ill-fitting set of false teeth." He went on to ask the legislature to amend the law to make New York safe for the investor. And that's what I will be asking the legislature to do again today. While it's true that everything old is new, we are using brand new tools of 21st century law enforcement I'd like to discuss with you briefly. One is our use of the provisions of the Federal Bank Secrecy Act and its guardian agency, FinCEN. Thanks to the sophisticated FinCEN database system, our office receives reams of suspicious activity reports, better known by the acronym SARS, each week. Financial institutions are required, as many of you know, to file these forms when they detect suspicious activity, and even where that activity does not in itself run afoul of the law. These reports are, in fact, the raw material of which major cases can be made. But as with so much in law enforcement, the challenge is to make sense of the large mass of information. To that end, in our office, we have created a SAR action team to search for actionable SARs on a daily basis. Analysts spend hours each week in our office conducting those searches for crimes and trends in areas that include Ponzi schemes, unlicensed money remitters, international money laundering, securities and other investment fraud, and mortgage fraud. If a SAR warrants further review, a team of ADAs and paralegals is assigned and works with investigators from my office, as well as outside partners like the IRS Task Force and the New York High Intensity Financial Crimes Area, better known as HIFCA. And let me just give you one example of why SARs have proven to be an invaluable tool. An analyst from our office, during one of the routine reviews that I talked about, came across a SAR and referred it to an assistant district attorney to investigate. That investigation led to the successful prosecution of a $100 million mortgage fraud ring, one of the largest mortgage frauds uncovered since the recent economic crisis, and led to convictions of over 20 individuals who lied, who cheated, and stole from dozens of financial institutions. And the lead defendant in that case was just sentenced to 8 1/3 to 25 years. That mortgage fraud case in which we secured a state racketeering conviction is just one example of how our casework continues unabated in the broader white-collar crime area. In the past year, since I became district attorney, we announced a deferred prosecution agreement with Barclays Bank in the amount of $149 million, which funds brought to approximately $400 million the amount that the Manhattan DA's office has returned to the city and state of New York last year. And in the area of tax fraud, we secured the convictions of 28 individuals for tax crimes that brought $25 million in tax restitution for the state and city of New York. And in another case, we successfully prosecuted medical professionals in a no-fault fraud mill using the novel theory that an entire no-fault clinic and all of its insurance claims were fraudulent because the conspirators concealed the true ownership of the clinic from the insurance carriers. These kinds of highly visible results have an added payoff. They encourage law enforcement agencies, financial institutions, victims, and whistleblowers to bring more cases through our door. And my hope is that over the coming months and years, you will see these efforts bear fruit as we go after ever more sophisticated financial crime. And a primary 21st century example of this is in cybercrime. The globalization of the internet has brought growth to our economy and an ease and an immediacy to our communications. But at the same time, it has allowed for the creation of what I call an unintended intimacy, a false intimacy, with people about whom we know nothing more than their email address. And it also provides a dangerous set of tools for the criminally inclined, not only to work their way into our personal lives, but to threaten our society on an individual and institutional basis. In fact, cybercrime and its close cousin, identity theft, are among the fastest growing crimes in the country. Some Manhattan police precincts report that identity theft is their most frequently reported crime. So ironically, while incidents of violent crime have largely decreased in New York, prosecutions for cybercrime and identity theft have grown at an alarming rate, up about 50% in the past 5 years.